Welcome to a July edition of TaxSnax. I'm Ben Symons and I'm presenting today with my colleague Shanzé Shah on two recent cases. The first is the first-tier tribunal decision of Louwman and HMRC, and the second is the Court of Appeal decision in HMRC and Bluecrest Capital Management Limited. Let's get started.
Okay, so let's start this with what was the background to the FTT case of Louwman and HMRC then?
Yeah, the case concerned Miss Louwman, who was a UK resident non-domiciled taxpayer. She was about to become deemed domiciled following tax changes that were introduced and were effective 6 April 2017. Just prior to becoming deemed domiciled, she set up an offshore trust like many deemed domiciled individuals did. And this was a concession that was introduced to allow deemed domiciled individuals to settle assets on an offshore trust, offshore excluded property trust, and it shields the income and gains on those assets from taxation on a current basis. And they're also protected from inheritance tax as well. But it's really the income and gains issue that was in issue in this particular case.
So the dispute in this matter concerned offshore income gains and accrued income profit, is that correct?
That's right, Shanzé. Offshore income gains are gains that arise on the sale of a non-reporting offshore fund. They are treated as income for UK tax purposes.
And then accrued income profits arise when securities that carry interest are sold, for instance, a bond with accrued coupon interest.
That's right. The portion of the sale price that reflects accrued interest will be treated as income and subject to income tax. So when a taxpayer sells a bond, it may have some accrued interest, and the accrued interest portion will be treated as income and subject to income tax.
Okay, and there were two issues in dispute in this case, weren't there? So the first issue was whether the income arising in Ms. Louwman's offshore trust was protected foreign source income, yeah?
That's right, Shanzé. The parties agreed that Section 720 of the Income Tax Act 2007 potentially applied. That section is the first charging provision of the transfer of asset abroad provisions, and that provision was engaged because Miss Louwman had transferred assets to her offshore trust. They were probably offshore assets, but even if you transfer offshore assets to, or you make a sale or transfer of offshore assets to another offshore vehicle, that engages the first charging provision of the transfer of assets abroad provisions. And the offshore income gains arising in the trust were relevant foreign income for the purposes of the transfer of asset abroad provisions. Okay. The parties agreed on that.
Yeah, and so Ms. Louwman then goes on to appeal on the basis that the offshore income gains and the accrued income profits were protected foreign source income under Section 712A of the Income Tax Act 2007, right?
That's right, Shanzé. This was a concession that was introduced to allow deemed domiciled individuals to shield protected income and gains in their offshore trusts from UK tax on an arising basis. The concession being that this income should only be taxed when it was remitted to the UK. Effectively, a deemed domiciled individual could accrue income and gains in their offshore protected trust, and provided it was protected foreign source income, they wouldn't be subject to tax on those income and gains on a current basis.
Okay, and then HMRC continued to maintain that offshore income gains and accrued income profits basically didn't fall under the definition of the protected foreign source income, and they shouldn't benefit from this concession.
That's right. HMRC maintained that these items of income did not have a source, and they could therefore not be said to have a foreign source. Effectively, HMRC was maintaining that Parliament never intended to include accrued income profits and offshore income gains in the meaning of protected foreign source income.
Yeah, and the tribunals kind of supported that because they decided the first issue in HMRC's favour, and they considered that the offshore income gains and the accrued income profits didn't have a source basically because they were just statutory items of income.
That's exactly right, Shanzé. The tribunal took a very strict construction of the statutes. They took a very strict construction of what was meant by protected foreign source income, and well, they said that offshore income gains and accrued income profits did not have a source and could not be said to be foreign source income. It was a tough result for the taxpayer.
Yeah, so we got that in favor of HMRC, the first issue, and then moving on to the second issue, you had the dispute which concerned with the tribunal looking at should they rectify construction of 721A of Income Tax Act 2007.
That's right, Shanzé. The tribunal had to consider whether they could take a rectifying construction such that offshore income gains and accrued income profits were included within the meaning of protected foreign source income.
And then the parties agreed that the principles in the Inco Europe Limited and First Choice Distribution 2000 case govern the ability of the tribunal to adopt a rectifying construction of a statute, didn't they?
That's right, Shanzé. The tribunal applied the Inco principles, and in applying the Inco principles, the court needs to be abundantly clear of three matters. The first is that they need to be clear of the intended purpose of the statute in question. Second, they have to be satisfied that the inadvertence of Parliament failed to give effect to that purpose. And third, they have to decide on what the substance of that provision would have been if Parliament had noticed their error.
And in this matter, the court just really couldn't get comfortable on the first two matters, could it?
That's exactly right, Shanzé. The court examined all the extra statutory material relating to Section 721A of Income Tax Act 2007. That is the section that contains the definition of protected foreign source income, and they considered that it was not abundantly clear that something had gone wrong with the drafting of the language.
So effectively, the court considered that they weren't quite sure that Parliament had inadvertently left offshore income gains and accrued income profits out of the meaning of protected foreign source income.
Exactly right, Shanzé.
And I guess in that sense, it is like an unfortunate loss for the taxpayer in this case. And then the tribunal did reach this decision with some reluctance and acknowledged that it may have been the inadvertence of Parliament that resulted in offshore income and gains and accrued income profits falling to be included in the definition of protected source foreign source income.
Yeah, that's right, Shanzé. The tribunal did reach that decision with some reluctance. The judgment creates two ongoing challenges for taxpayers. The first is that they should wait for the first challenge is that taxpayers should wait for the outcome of any appeal before deciding on how to proceed. I'll start again. The judgment creates two ongoing challenges for taxpayers. The first challenge is whether they should wait for the outcome of any appeal before rectifying their affairs. There is definitely, interest will apply if there is an adverse outcome on appeal, and it's possible further penalties may apply as well. So that is the first dilemma that taxpayers face in relation to this judgment.
Yeah, and then the second would be is that if they do decide to pay tax on their offshore income gains and accrued income profits, they need to be quite clever about the way they repatriate their income in order to avoid triggering further UK tax charges.
That's correct. Louwman was an interesting case. That's right, Shanzé. Yeah, Louwman was an interesting case. Let's move along to the case of Bluecrest, HMRC, and Bluecrest Capital Management Limited.
Okay, so could you start by giving us a bit of background about the case?
Yeah, certainly, Shanzé. There should be a PowerPoint slide being displayed on screen, and I am going to talk to that slide. Bluecrest is a well-known London hedge fund. It was structured as a limited liability partnership, and that is the typical structure of a hedge fund. A limited liability partnership has limited partners only. Mike Platt, who is the well-known London hedge fund manager at the helm of Bluecrest, he managed the Bluecrest Limited Liability Partnership through a Jersey limited company, and that will appear on the left-hand side of the PowerPoint slide that is being displayed. And in the course of giving judgment, the judge described three different classes of limited partner members. The first class of members was infrastructure members. Infrastructure members in 2014, there were 16 infrastructure members, and they are members involved in management, HR, managerial functions. The second class of members that the judge described were portfolio managers or discretionary traders. There were 48 of those members in 2014. They constituted the largest group of limited partner members. And the third group of members that the judge defined in this case were other front office staff, quants, technologists, etc. There were 18 of those members in 2014. So the second group, portfolio managers / discretionary traders, make up the bulk of the limited partner members.
Okay, so that's how it was all structured. What were the matters in issue at this case?
The chief matter in issue was whether the limited partner members were effectively employed by the limited liability partnership or whether they were effectively self-employed. If they were self-employed, Bluecrest did not have to pay PAYE or national insurance contributions in respect of those members.
Okay, and so essentially Bluecrest had to pay 55 million or something like that in national insurance contribution as if the limited partner members were effectively employed.
That's right, Shanzé. That's essentially what this dispute was about, whether Bluecrest had to pay £55 million in national insurance contributions because the limited partner members were effectively employed.
And how did they decide whether those members were effectively employed and should be taxed as that?
There were three conditions introduced in sections 863B to 863D of ATOIA 2005. The government introduced this test because it was too difficult to introduce after consultation, the government determined that it was too difficult to have a common law type employment test. And over to you.
Yeah, if you want, I can go through the conditions. So I'll start with the first one. So you had, as you said, there's three conditions, A, B, and C. Condition A is that it is reasonable to expect that at least 80% of the LLP members' remuneration will be fixed. 1. 2, variable but without reference to the overall profits or losses of the LLP, or is not in practice affected by the overall amount of profits or losses of the LLP.
That's right. And condition B, and this should be displayed in a PowerPoint slide that is displayed in this presentation. Condition B is that the mutual rights and duties of the members of the LLP do not give the member significant influence over the affairs of the partnership.
And then lastly, to the final condition C, the members' contribution to the LLP is less than 25% of the members' expected disguised salary.
That's right, Shanzé, and where all three conditions are satisfied, a limited partner member will be treated as though they are employed.
And in this matter, the parties agreed that condition C was satisfied.
That's right, Shanzé.
Yeah.
And it was conditions A and B that were in dispute.
Yeah. So the central issue, whilst they both were in dispute, the central issue was B. That was the main one in dispute.
That's right, Shanzé. If we move along to the next slide, we can see the a discussion of the central issue that was in dispute.
And so we see that, which was condition B, and then you've got condition B in the next slide in quite a bit of detail there. So I'll just go through it. So condition B states that the mutual rights and duties of the members of the limited liability partnership do not give the member significant influence over the affairs of the partnership. And then you have the source of influence and then further displayed on the slide.
Yeah, so at a first-tier tribunal and upper tribunal level, the first-tier tribunal and upper tribunal considered that a member would have significant influence where they had de facto control or significant financial influence. In the case of a portfolio manager, that was where they managed £100 million or more, and most portfolio managers would manage £100 million or more. Therefore, at a first-tier tribunal and upper tribunal level, they were satisfied that most of the members would effectively satisfy or would effectively fail condition B, which is what Bluecrest wanted. So effectively at a first-tier tribunal and upper tribunal level, Bluecrest won on condition B. However, the matter went to the Court of Appeal, and Lord Justice Henderson and the Court of Appeal took a different view. He took a very rigorous approach to statutory interpretation, and he determined that it was really the rights and duties arising from the LLP agreement, and he focused very heavily on the LLP agreement, that would determine which members had significant influence. And following that approach, it would be a relatively small number of members that would have such influence. He also noted that the scope of a member's influence was important. He considered that it was decision-making at a strategic level that was important, not having not how a member performed their duties on a day-to-day basis. That is, not having control of a significant amount of money. You know, even if a portfolio manager managed £100 million, that was not enough. They had to have influence at a strategic level in order to have significant influence. And Lord Justice Henderson therefore considered that most members would probably satisfy condition B, but he did send the matter back to the first-tier tribunal for further factual determination.
Okay then, so now we go on to the next slide. What about condition A, Ben?
Yeah, condition A is that it is reasonable to expect that at least 80% of the limited liability partnership members' remuneration will be 1, fixed, 2, variable but without reference to the overall profits or losses of the limited liability partnership, or 3, is not in practice affected by the overall amount of profits or losses of the limited liability partnership.
So essentially, the Court of Appeal considered there must have been more than a link to the profits in the remuneration period to a member for condition A to be satisfied. And so the court considered that a member needs to be entitled to a share of the profit in order to fall outside of this condition.
That's right, Shanzé. Effectively, most members would fall within this condition. They were entitled to profit-linked bonuses, but this was not sufficient. They were not entitled to a share of profits. Being entitled to a profit-linked bonus is not the same as receiving a share of profits. Most members would have satisfied this condition, and this is clearly not what Bluecrest wanted.
Yeah, and the Court of Appeal essentially agreed with FTT and the UT in that most members of the LLP would satisfy condition A. And as you said, that's not what Bluecrest wanted. Exactly,
Shanzé. Most members would satisfy conditions A and B, and the parties had agreed that all members would satisfy condition C. Therefore, the members were effectively employed, and Bluecrest had to pay 55 million or around 55 million pounds in national insurance contributions.
Wow. And looking at this from a policy point of view, this does kind of create issues for many taxpayers who may have followed HMRC guidance. And you could say that the Court of Appeal's approach is at odds with HMRC's guidance and may see many taxpayers revising their positions and previously lodged returns.
Yeah, in this sense, it's an unfortunate outcome for some taxpayers from a policy point of view.
Yeah, but Bluecrest has obtained permission to appeal to the Supreme Court, so it will be really interesting to see how that turns up and if Supreme Court agrees with the Court of Appeal or not in this matter.
Brilliant.
Yeah,
Okay.
thanks so much, everyone.
Thank you. Yeah.